So New Jersey just told the Supreme Court that they do not need to review the state's magazine capacity restrictions. So let's talk about this. But real quick before we jump into this video, if you think that magazine capacity restrictions is unconstitutional and violates your Second Amendment rights, go ahead and hit that like button and subscribe. I also want to give a shout out to one of the main sponsors and supporters of the channel, and that is USCCA. Through your membership, you get training, education, and self-defense liability protection. So if you're in the market for something like that, if you carry a firearm, I highly recommend you take a look into USCCA, and I'll put a link to them down in the details section. So what we're going to be talking about in this video is a brief filed by the state of New Jersey in the ANJRPC v. Grewal case. This is a challenge to the state of New Jersey's magazine capacity laws, them restricting magazines to 10 or less rounds, essentially not allowing people to have magazines that hold more than 10 rounds, defining them to be LCMs or large capacity magazines, similar to what other states have as well, like the state of California. In June of 2018, New Jersey passed Assembly Bill 2761, which banned the possession of firearm magazines with a capacity of more than 10 rounds of ammunition. The New Jersey law required owners to modify their magazines to permanently reduce their capacity, destroy them, or to turn them over. In August of 2018, the district court denied ANJRPC's motion for a preliminary injunction, and they applied the flawed two-step analysis that we've talked quite a bit about on this channel. This analysis claims that the core of the Second Amendment pertains only to the need to defend oneself in the home, and that any exercise of gun rights outside of that core is less important and can be easily infringed on, essentially. And that is how we have found ourselves before the Supreme Court, because a writ of certiorari has now been filed to the Supreme Court, requesting that the Supreme Court review this issue. There are two questions presented to the Supreme Court in this case. The first is whether a blanket, retrospective, and confiscatory law prohibiting ordinary, law-abiding citizens from possessing magazines in common use violates the Second Amendment. And the second question is whether a law dispossessing citizens without compensation of property that was lawfully acquired and long possessed without incident violates the Takings Clause. In response to the writ of certiorari, the state of New Jersey is now opposing the Supreme Court reviewing this case and essentially argues in their response that the Supreme Court does not need to review this issue. When you look at the brief filed by the state of New Jersey, they state that for 31 years, the state of New Jersey has placed careful limits on the maximum capacity for an individual firearm magazine. The New Jersey legislature has consistently adopted this policy on the basis that large capacity magazines, or LCMs, are used disproportionately in mass shootings and enable more shots to be fired in less time, without requiring the shooter to even pause briefly to reload, thus causing far greater harm in mass casualty events. But while New Jersey law limits how many rounds each individual magazine could feed into a semi-automatic weapon, that law does not interfere with individuals' ability to own and possess as many firearms and as many magazines as they choose. It also provided multiple avenues for them to come into compliance. First, all owners could transfer the magazine to any person or firm lawfully entitled to own or possess that firearm or magazine. Second, owners could render the magazine inoperable or permanently modify a large capacity magazine to accept 10 rounds or less. Third, they could voluntarily surrender the magazine. And finally, owners of firearms with magazine capacities of more than 10 rounds that were incapable of being modified to accommodate 10 or less rounds just had to be registered within that year. Now, the main argument of the brief by the state of New Jersey can be summed up as simply that cert should not be granted because the plaintiffs here, ANJRPC, have not met various criteria for a cert review to be granted. First, they argue that there are no circuit splits. They argue that the 1st, 2nd, 4th, 7th, and DC circuits have all upheld nearly identical magazine capacity limits against nearly identical Second Amendment theories, and no other circuit has reached a different result. One interesting thing, though, is they do reference the 9th Circuit Duncan decision, which is in relation to California's magazine capacity restrictions. And essentially, they say that Duncan's contrary decision by the 3-judge panel does not create a circuit split because that is going to be reviewed en banc, or arguments for that have occurred, and that since the 9th Circuit is likely going to overturn that 3-judge panel's decision, that hasn't led to a circuit split and hasn't led to a, ripe situation for the Supreme Court to review this issue. Now, New Jersey also argues that since the plaintiffs also stated that the Supreme Court could hold this case until they finally determine the whole Corlett case, that is a case that is going to be reviewed by the Supreme Court. Supreme Court review has been granted in that. That is a challenge to the state of New York's carry permit laws. So plaintiffs there said, hey, Supreme Court, if you want to hold this case until you determine that one, you could do that as well. Here, the state of New Jersey is saying, hey, Criteria for holding this case has not been met. You should not hold this case until you hear Corlett. Just reject this case review altogether. So the state of New Jersey stated in their brief that that case involves a meaningfully distinct issue, i.e. whether denial of certain individuals' applications for concealed carry licenses violated the Second Amendment. While both cases, of course, involve the same underlying constitutional provision, they involve challenges to entirely different laws. So here you can see the state of New Jersey is saying you do not need to hold this case until Corlett. The flaw in that is the fact that there are so limited Second Amendment cases that the Supreme Court has addressed. Even though Corlett involves a carry permit issue and this one here involves magazines, the Corlett case will still undoubtedly have a big impact on all Second Amendment cases and will be cited by every single Second Amendment case likely that comes after the decision in Corlett. In fact, the state of New Jersey also kind of accepts this later on, and they say that even if this petition is denied here at this moment, there is nothing that would prevent litigants from reinitiating a challenge to the New Jersey capacity restrictions based on Corlett if they believe that that eventual decision ultimately helps them. So they're saying you can kick it right now, and if Corlett is maybe citable on this issue, they can just relitigate this case, just bring the challenge again. But again, that's going to lead to many more years down the road. You're going to lead to completely new litigation, district court, at the circuit court level, and then eventually up to the Supreme Court, when in fact, they are kind of acknowledging there could be the potential that Corlett affects this case. So why shouldn't then the Supreme Court just hold this, see what Corlett says, how they determine Corlett, and then at that moment, if Corlett does apply, the case is already teed up for the Supreme Court to review. Now, another big argument made by the state of New Jersey about why the Supreme Court should deny review in this case is that this magazine capacity restriction in the state of New Jersey is consistent with the Supreme Court's decision in Heller. They state that there is no evidence that anyone has ever needed a magazine with more than 10 rounds to defend themselves. And here they are trying to tie the whole magazine issue related to self-defense. They're saying Heller only addressed protections under the Second Amendment if it applies to self-defense. You don't need a magazine with more than 10 rounds for self-defense. Therefore, this falls outside of Heller and we can kind of use a different type of analysis. Here they use one of those arguments that we also saw pop up in the Ninth Circuit Duncan v. Bonta case, simply being that if you get yourself into a bad situation where you maybe need more than 10 rounds, all you have to do is reload or use another gun. That's what a lot of these states argue, like the state of California, and the state of New Jersey is once again arguing here. Now, one of the last main arguments in the brief has to do with the takings clause issue under the Fifth Amendment. Here, the state of New Jersey is saying that this magazine capacity restriction does not affect the takings clause. And the whole argument here can be kind of summarized as you have the ability to permanently modify these magazines to hold 10 rounds. You have the ability to destroy them, to sell them, turn them over. You have other avenues to actually get some sort of value, I guess, out of your property to where this doesn't affect the takings clause. It isn't a permanent seizure of your property without compensation. And so here they're just saying that this doesn't violate the takings clause when in fact it does. So those are the main arguments presented by the state of New Jersey about why the Supreme Court does not need to address this case, why they don't need to review it, and why they should actually deny review. So if you guys have any questions, go ahead and comment down below and I'll try to answer the best of my ability. Also, if you guys like this video and like support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, it helps to fuel Algore's rhythm, and it just signals to YouTube that you guys see value in these videos, in this type of 2A news, and then it pushes it to more individuals. I cannot thank you guys enough for liking, commenting, and subscribing. You are definitely having an impact on these videos, on this channel. I'm seeing a ton of people commenting down below that my videos popped up on their YouTube feed. They've never seen my videos before, but the algorithm is definitely helping to be pushed and to reach more people. So thank you so much for doing that. Go ahead and drop a comment down below that you're commenting to fuel the algorithm, that you're throwing some more fuel on the fire. I really appreciate that. And as always, thank you all for watching. Don't forget to like and subscribe. And never forget, this nation was built by armed scholars and this nation will be maintained by armed scholars.